This is Paul. Yes, I had to make a call this morning. I decided it'd be best to not do the work and maybe do it on Tuesday afternoon. Pooch. I'd seen one guy that I went to church with twice this morning. Yes, once. Well, that's coincidental. But then I started kind of getting convicted. Yes, that I should go to the Apostolic Pentecostal Church tonight at 6 p.m. Oh, when I saw Joe driving by twice this morning, and then I'd seen another pastor, I was kind of getting that nudge from the Holy Spirit that I needed to go to church. Yes. So I called the friend that I have that was going to have me do the yard work. Yes. I said, well, I think the Lord wants me to go to church today. Yes. And I'm just going to sit here for another few hours making these videos, and then I might even have to take a shower, might not. It's really dependent upon me being able to get $1.50. Poach. And then I'd have to shower and change my clothes, and it's very involved being able to go to church. Now, there's what this information to be provided by the prosecutor at first appearance. Yes, Several studies have found that basic information typically available provides as accurate of a prediction of abuser risk to the victim as more extensive and time-consuming investigations and assessments. Yes. In Washington State that is, a great deal of relevant information should be provided to the court by the prosecutor. Yes. Some courts have charged pretrial staff with collecting information relating to risk. Yeah. RCW 1099.4045 states a defendant arrested for domestic violence shall be required to appear in person before a magistrate within one judicial day. After arrest, and requires a prosecutor to provide the following information to the court at first appearance, after arrest, and arraignment. Pooch. Now, I was never arrested for the violating of the, what did I put here? The defendant's criminal history, if any, that occurred in Washington or any other state. Yes. If available, the defendant's criminal history that occurred in any tribal jurisdiction. Yes. And then the defendant's individual protective order history, which lists all civil and criminal domestic violence orders the defendant has been subject to. Poach. Now, this arraigning of myself, I'm sure that Brett Roberts made sure that Judge Landis had every protection order that I've been subject to. Yes. From 2011 when I wasn't given due process. Right. When you reissued it by minute order. Ouch! When I was arrested and you served me the dissolution of marriage at the same time. Yes. When I went to court and was found not guilty of violating it because I didn't violate it. And then the temporary protection orders that were unnecessary. Now, just wanting to know, because it says here that the prosecutor is required, yes, to give all that information to the judge. Yes. Did you get my complete criminal history? Because I've been arrested numerous times, but I've never been convicted of any crimes. Yes. And then it looks like in Washington State, bail prior to court appearance. Yes. In Westman versus Carey, the Washington Supreme Court upheld the Spokane District Court rule, which requires all defendants arrested for domestic violence crimes to be held without bail pending their first court appearance. Yes. Court found the right to bail under Washington State Constitution, Article 1, Section 2. Yeah. Does not attach until the time of the preliminary hearing, when the court will review probable cause and make individual determinations as to bail and conditions of release. But I realize that you didn't use law enforcement to arrest me. No! You filed a 2-count criminal complaint as a civil violation of the restraint provision. Well, since you filed, well, there was no is it a criminal complaint when you deprive somebody of bail, motherfucker?